Hello friends, with the great initiative of Company Law Institute of India Private Limited, we have started this series of income tax cases. In our series today we are going to discuss a very important case which has been decided by the Rajasthan High Court in a writ petition filed by the legal heirs of the Assessee. This case has been reported in 448 ITR at page number 25 and the date of the judgment is 15 September 2022. The facts of the case are very interesting. In this case, the assessment year was 15-16 and for that assessment year, the assessment of the assessee was already completed under section 143 subsection 3 6 years back. When the assessment under section 143 subsection 3 was going on, it was brought to the notice of the assessing officer about the death of the assessee, and this fact was also acknowledged by the assessing officer at that time while writing the assessment order. After that, 6 years, notice under section 148 was issued to the assessee. The legal heirs were not able to respond to that notice and consequently the assessment order under section 147 read with section 144, that is best judgment assessment, was passed, creating a tax liability on the assessee. When the legal heirs came to this assessment order, they filed a writ petition in the Rajasthan High Court. As usual, the plea of the department was that it was not brought to the notice of the department, who was the respondent in this case, about the death of the assessee. But this point of the department was not as per the facts and circumstances of the case. The legal heirs of the assessee said that when the assessment was done 6 years back, this fact was brought to the notice of the assessing officer which was there at that time, which was duly incorporated in the assessment order. So the department cannot take this plea that they were not aware about the death of the assessee. So, relying on the various judgments of the various high courts and even the Supreme Court, there is a very famous case of Supreme Court Maruti Suzuki in this regard, and the various high courts have already decided in favor of the assessee that if the notice is issued to a dead person and the assessment is made consequently, then that notice and the assessment will be null and void from the scratch. Now the question arises that whether it is the duty of the legal heirs of the assessee to intimate to the department about the death of the assessee. In this regard, the judgments are there which say that it is not the duty of the legal heirs because it may happen that there are more than one legal heirs. So, who will intimate to the department? This question arises. So, if we go legally, then there is no particular requirement on the legal heirs of the assessee to intimate to the department. But as my point of view, it is always better to comply with the law. If you are the legal heir of any person who is dead, then it is always advisable to intimate to the assessing officer through email ID along with the death certificate, and also take a receipt from the ward of the assessee of the paper submitted to the department that this person is no more. If we will do this type of homework, then it can save us from the unnecessary assessments or reassessments which may be done by the department after the death of the assessee. The department has every right to issue the notice to the legal heirs and complete the assessment. It is not like that the assessment of a person who is dead cannot be done. It can be done by issuing notice to the legal heirs, but the assessment order cannot be written in the name of a person who is dead. So it is always advisable to intimate to the department through mail or by sending the papers manually, or if it is not possible, then we should at least send the documents by speed post. So it will save us from unnecessary litigation. At the end of this video, once again I am repeating the name of the case. The name of the case is SHOBHA MEHTA versus Assistant Commissioner of Income Tax. Thank you, friends.